Let's do this. Let's go down to Louisiana and see what's going on with the Parole and Pardon Board.
03 France Drive, Shreveport, Louisiana, 71118.
Thank you, sir. And you have some folks on Zoom today who want to speak on your behalf. Your wife, LaWanna, your sister, Sharika, and Shanika, another sister.
Sharika wasn't that she had to work, so my other sister,
Shanika?
Andrea Brown.
Okay.
She went, the other one started the job.
It's okay. Well, thank you for that. That's another sister?
Yes, ma'am.
Okay. So, sir, let me just read some identifying information into the record. Then I'm going to turn it over to Mrs. Stapleton because your case was assigned to her.
Yes, ma'am.
Did you expect Mr. DeVargas here with you today?
No, ma'am.
Okay. Because I have him listed as your attorney.
He had been my attorney long.
Okay. All right. So, Mr. Charles, you're classified as a first offender. Your DOC number is 497990. You're seeking a pardon with restoration of firearms. You were sentenced in January 2005 to a 5-year sentence that was suspended. You were placed on 4 years probation for the crime of simple burglary.
Yes, ma'am.
That's correct?
Yes, ma'am.
All right. I'm going to turn it over to Mrs. Stapleton.
Okay, please tell me something about what happened.
I had just moved back from New Orleans and I was, as they say in the streets in New Orleans, and I thought that I could come back home and do the same thing, and I didn't have nowhere to live, and I kind of,
How old were you?
I'm 41 now, so I don't know if you tell me.
Okay,
When it says on your application.
Yeah, so, but I went, and go into a clothing store, just trying to get money for someone to live. And I got it. So,
yeah, I saw where they recovered everything.
yes, ma'am, they got it.
So, I see that you had 5 years suspended
Yes, ma'am.
and 4 years of probation.
Yes, ma'am.
Tell me about your life since then.
I had a daughter in 2011, and I've just been on the path of trying to be better, be a better example for them, because I knew how when I was in jail, how my mom came up and, family and cried and all this stuff. And I just didn't want to be like that with my kids. I got 3 daughters, so just working. That's all I do is work on stuff. I do airman jack of all trades. I've been on the job I'm at right now. I just made 4 years. I think yesterday. I got the Rising Star Award in 2 positions I've been in since the 4 years I've been in this company. And I'm like the to-go guy. It's pretty much been brought me all over the United States, Hawaii, and all that stuff for the company.
Really?
Yeah, I've been to Hawaii, all the islands. They sent me out there, and I'm the one they call when they need stuff done. And I learned that I'm really good with my hands.
Yeah.
Instead of doing it the bad way, not do it the positive way. And it worked. I mean, I didn't know that I was so inclined to doing everything when I did stuff positive. So, but I had a bad childhood that kind of led me to doing stuff the wrong way. I had to be an example for my kids, so I made sure I did it. I give back a lot. I go and speak at, my uncle has a church in Anchorage. I speak to the troubled kids. He has like a program we do every summer, go to church and kind of tell them where I went, where they could go. They tell me what they want to do in life. I tell them you need to have a backup, because these kids these days, they want to be a streamer or something like that. And
Yes.
what if they don't work? I'm just trying to put them on a better path of leading that life, because, Nag's is a small town. You get caught up real quick or, killed. So trying to help them out. And it's just pretty much what I've been doing since then. I'm with another organization where we do runs every year. And we donate money to different donations, foundations and stuff like that. I just did one for a battered woman shelter I want to say a month or two ago, raised some money for them. Got to bring the letters. sitting
That's
in
okay.
My glass thing, but I try to do better, because, I mean, these kids need better these days, so.
I know, well, a lot of children, like you said, like the streaming and stuff like that, that's where they're unfortunately getting a lot of their guidance from, which is getting them in trouble. So
Yes,
people
yes.
like you come along and you say, and this is what trouble looks like once it happens to you. So that's a worthy call and calling too.
Yeah.
You know, and so I'm proud to hear from you that you're doing these things, these positive things with your life. You're unopposed by the sheriff, the district attorney, the sentencing judge. So that speaks well to everybody. That you haven't had any more problems in your life. And like you said, you move on. And yeah, the term that used to be confidential to this day is jack of all trades.
Yes, ma'am.
And that's a good thing to be because you can do a little bit of everything. And then, and we need a lot of people like that.
I stay at home. I'm always keeping myself busy. I literally worked all day yesterday on my kitchen. Got up 3 o'clock this morning and got on the road to come in. So
Well, that's wonderful.
I'm going to work when I get back.
I think we have some more people that would like to speak on your behalf. Your wife,
Yes.
Ms. Charles, would you like to speak, please? She on Zoom?
She there?
Here she.
I'll this is about.
I'm one of his twin sisters. I speak if nobody else gonna speak.
Okay, go ahead.
Hi, my name is Shirley.
Hello, I'm so sorry I'm here.
Oh, I'm sorry. I'm sorry. Let me
No,
get
I'm
back.
here. I'm at work, so 1 second. I have to step away. Okay, I'll be right back, okay? I am so sorry. I'm currently at work. Yes, I'd like to speak on his behalf. DeMario has been amazing. I've known him for over 10 years. I mean, he's the reason why I moved to Shreveport. And he's just been, ever since I've known him, he's been a really, really good guy. I've never seen anything bad he does. He donates, he does the storage auctions, and whatever he has left over, he will donate it to the needy. He, like he said, I heard he said that he does runs and they donate. I believe he just did a run for one of the houses here that holds homeless, and he donated there. He has his daughter, he's had custody, he fought for her, he's been trying to help her, you know, he puts her in counseling for everything that she's been through. He did go and speak for one of his uncles at a church, you know, to get the younger youth to go on the right track. And he does that because of what track the road he was previously on, and he don't want them to go on that route. So, you know, he's been doing a lot for his community. Mario has been wonderful side of him.
Thank you very much. Ms. Charles, would you like to speak now?
Can y'all hear me?
Yes, ma'am.
Mario has always been my baby, and yeah, he took the wrong road, but then he turned his life around. He's married, he takes care of his kids, he bought a house. And for me, the biggest thing for me that I wanted to talk about was me. I got 6-7 years ago with MS. I went down fast. I was down for about 3 years, and the Mario was there for me. He took care of me. He made sure I had food, anything I needed. If I needed money, he sent it to me. He just really stepped in for me in that time, and I appreciate him. He just has changed the life. If I need my car fixed, he come and fix it. Like anything I need, he coming. And I just really appreciate my little brother for that. And that's what I wanted to talk about and say. I'm sorry. I'm getting emotional. I'm sorry.
That's okay. Well, that's wonderful to have a brother like that.
Okay. I would like to speak. I'm his other twin sister. The one that just spoke, me and her are twin sisters. My mom had us on her birthday. She's deceased though. But I can say a lot about my little brother. He's always been there for us. I recently, probably about 3 years ago, went through a hard divorce. I was married for 17 years, so it's been hard on me the last 3 or 4 years because I was so used to having someone to help me work on my vehicles. Me and my daughter's in college, and so she travels a lot, and so we started having issues with our vehicle and stuff. And like he is really a jack of all trades. Like Mario didn't go to school for a lot of the stuff he does, but just the last year, you guys, I had some stuff on my vehicle that was going to cost me. My daughter's vehicle and my vehicle was going to cost us $4,000 and $5,000, $6,000. And DeMario fixed stuff on my vehicles, my daughter's vehicles. My daughter is a student at Grambling University, and I didn't know where the money was going to come from to get that vehicle fixed. But I mean, when I tell you he fixed both of our vehicles, didn't charge us a dime. Now we still gave him money just to say, tried to give him something just to say thank you. But anytime I need him, guys, because when I left, my husband took everything from me, so it left me with nothing. And anytime I call him, if I need money on a bill, anything, he's there. And we have we have nephews or sons in our family. I have a son. He's 26. My twin sister has a son. And we have other boys in our family, nephews and stuff that he clowns around and he makes us laugh. But when he's serious, he gets those boys, he pulls them off to the side and he lets them know, look, I made one bad decision, but look how I turned it around. Look where I'm at now. Look what he talks to those boys and he lets them know that I made one mistake, but look how I turned around. Look where I'm at now. Like he really counsels those boys. My son looks up to him. Our other nephews and boys in our family, every time we have family gatherings, he talks to them, let them know, look, this is not the path to go. He really does. He really, really impacts those boys in our family, and I appreciate him. I love my little brother. My oldest brother, it's 8 of us, and my oldest brother passed away. And he's always been like we call him the little big brother, because even though we had an older brother, my older brother, he had a lot of issues and drug usage, and he died. He had a hard life. But to me, DeMario has always been the big brother because he was always mature for his age. And so I really thank God for him. And he's always, anytime I call him, guys, when I tell you he comes through, he comes through. And I thank God for him. So I really appreciate you guys taking the time out to listen to us on today. And God bless you guys.
Thank you very much.
Thanks so much.
Well, you're a wonderful family man too.
Yes.
Okay, well, I'm going to pass it along to anyone else on the panel.
Yeah. Is there any other questions?
Yes.
Okay, Mr.
Were
Prater.
you arrested in 4/7 of 2013 for misdemeanor criminal trespass?
Yes, sir.
Okay, where was that?
Houston, Texas.
Okay, and did you got convicted? Were you on probation or anything?
No.
Okay. All
I
right.
had to pay a fine. My neighbor stayed in apartments, like a two-story apartments, and one of the guys, some of the guys that used to hang out on my steps, was sitting in front of the house. The neighbor had me watching his apartment, stay right next door. I was dealing with a girl in the apartments, and as I walked back to my house, the guy was sitting on the step. I went up to the second floor. He was at the middle of the step. Time I got up the step, police pulled up and arrested both of us. I explained to them that I lived the next door. The guy had just left to want to go out of town because he was going fishing. And they arrested me, even though I showed them paperwork and stuff like that. They dropped the charge. And I actually lost my apartment. I had to move back to Louisiana. That was 2009. It took them years, and I was working for DirecTV at the time in Texas. Somebody passed by my vehicle and knocked my side mirror off my direct van. State trooper came in Houston Springs, Texas, and they ran my name and said that there was a warrant out for my arrest. So, good thing the officer was nice. He let me drive my direct TV van to the police station. They put me in, and I had to go back and forth to Houston. Actually, I was working every time I would go. I would work while I was down there for court, and they gave me a fine for trespass.
And that was in 2013.
Yes, around that time. Yeah, because it happened in 2008, but they dropped it and then they picked it up without me knowing. Because I guess they might have sent the letters to the apartment, but they had kicked me out the apartment because they thought I broke into the next door neighbors. But they had me charged with something else at first.
Because it says you were arrested in 2013.
13?
Yes, sir.
Yeah, they picked it back up.
Okay.
That was 2013 when the mirror got knocked off my baby.
Okay. And on the burglary, we only talked about the roof burglary.
Mm-hmm.
How many burglaries did you?
It was 2. It was in a week of time. It was, okay, so I'm trying to think, this was a long time ago. A guy that I grew up with, I had when I was a juvenile, we used to do crazy stuff, break into different things like that. We got arrested. Nothing happened because we were minors. Met back up with him, I guess, after he got out of Tallulah. And I didn't know that he was breaking into businesses and stuff like that. And like I said, I was on the street. So we went and broke into a tractor store and broke in a penny machine and stole the pennies and old laptops, stuff like that. And once we left out, we got arrested right down the road. And then I got arrested for that, then got out, and then that's what happened with the store going to the roof.
Okay. What about Hall's Glass
Oh,
and Spears Cycle?
that was the
And
stuff that's what I was talking about. That was the stuff he was doing before I even was around him.
And the UPS store and
That
Freeman's
was-
office supply?
Yeah, that was the place the place that we broke into was the tractor store. That was the only thing I did with him. He did all that stuff prior to me knowing that he had did it. I didn't find out that stuff until I was in jail. They just kept on bringing me papers about more charges they had put on me from that. But they found all the stuff in his possession.
Did you plead guilty to all those?
I honestly don't remember.
Because I think you pled guilty to 5 counts.
Yeah. So, yeah, yes, sir, because I got the drug court.
Yes, sir.
Yes, I was drug court.
Mm-hmm. It was
But I was just concerned about the 2013 thing, and you explained that away, but the 5 counts of burglary is different than the one count of burglary for me.
Yeah, I understand. I had, like I said, he was out doing all that stuff before I had met up with him, so I didn't know anything about it until after. And the lawyer that I had was doing so much of a terrible job. My aunt, which was tax assessor of Natchez, had to fire him because he was trying to get me to plead for something I didn't do. So the lawyer that she brought in, they were like, the only way you get out of jail right now, or we'll have to sit there and wait is plead for the guilty on the burglary and do the drug court stuff.
Okay, that's okay.
So as part of that plea, also you were ordered to pay a fine of $1,000. Did you pay that fine?
The 2013 thing?
In the, for the simple burglary in Natchez.
Natchez. I believe so.
It says, you were ordered to pay $1,000 fine, but the sheriff's office couldn't find any record of any payment being made. So do you remember doing that?
I was paying because I was on probation in Shreveport. I was in probation on probation in Natchez, and then I transferred to Shreveport. I was paying stuff because they gave me the department until I paid everything off.
That
Because I
was,
went and signed over for the first time offender pardon at the probation office in Shreveport. So they would, I had, I think like one more payment before they would sign over the payment for the first time offender pardon.
all right. So, because it says it was noted that that Charles had not paid the $1,000 fine in its entirety as of the date your probation expired.
That's great, because they wouldn't even give me the first time offender pardon when I first got off of it until I finished paying it off through the street for parole, probation and parole.
Any other questions?
Okay.
I think we're prepared to vote. Mrs. Stapleton?
Okay, well, my vote today, Mario, is to grant your request for pardon with firearms. And, I think you've done, thank goodness, extremely well with your life. All of that had happened 20 years ago and 21 years ago, in fact, in 2004, as far as the clothing store. And then the incident in 2013, yeah, I saw that there was a plea bargain made with that too. So that's going to be my recommendation, to grant with pardon with firearms.
Mr. Prater?
My vote's to deny.
Mr. Freeman?
My vote is to grant with firearm.
Mr. Tillis?
My vote is to grant with firearms.
My vote would be to grant your pardon with firearms, but I need proof that you paid that fine. It's gonna be up to you to verify that. So you've received the required 4 votes to grant your request, but we will not submit it to the governor until you show proof that you've paid that fine.
Okay.
Okay?
So,
You'll have to figure that out.
All right, meanwhile, we'll do what so many of you like to do in the month of January. Let's head to Florida. Are we going to head to Florida? Go down there, see what's going on with Judge Mercer. Oh, I love Judge Mercer. First appearances.
You have a warrant out of Clay County, Georgia. I know that you've had a chance to talk to Mr. McDaniel about the waiver of extradition process. I do not know if you've had a chance to talk to Mr. Green about that process. So Mr. Green, let me just see Mr. McDaniel, tell me where he stands and we'll see what Mr. Green's thoughts are. Mr. McDaniel?
He was going to sign the waiver, so I'm not sure what. I'll talk to Mr. Green first.
Okay. So Mr. Green, he says he would like to talk to you before signing that waiver. Is that right, Mr. Peeler?
And I can sign it, whatever he recommends.
So Mr. Green, what do you want him to do? Or what do you recommend he does as far? Do you have a recommendation for him?
Judge, I guess.
I think you always could, but they didn't. So back years ago, states chose not to extradite on misdemeanors, and now, like our county and apparently this county in Georgia, will put a radius limit on it. We'll go get you out of state, but only will go X number of miles. For instance, Jackson County will not go to North Alabama and get somebody on a misdemeanor, but we'll go within a couple hundred miles. So I think somebody's talking there at jail. I couldn't hear who that was. I don't know. But so ours are the same way. I think ours is set at 2 or 250. This warrant, Mr. Green says that particular county will pick you up within 150 miles. And they have notified our sheriff's department that they'll come get him from here. That's all I know about it.
And Mr. Green,
if you want time to research it, Mr. Green, just a second, Mr. McDaniel. If you want time to research that, Mr. Green, that's perfectly okay. He's just not going anywhere because he's got a warrant from another state. Mr. McDaniel, we're trying to say something?
Yeah, Mr. Green, I guess in the past, they have not extradited him. I'm not saying they won't, but I suspect if he signs this waiver, they're going to call today and find out. So you're going to have to do your research. They either are or they are not. You know what I mean? And if he doesn't sign it, I mean, we're going to sit here until we do call him. I mean, someone's got to call him. Jail's going to call him today. And if they don't want to come get him, they're going to let him go. I'm not positive they're going to come get him because in the past, they did not come get him. So I'm not positive they're going to come get him this time.
I have no authority to set a bond on an out-of-state warrant. under Florida law, they have 30 days to pick him up, but he will know today if they're coming to get him or not, and that I review the cases at 15 days. This county, Fort Gaines, which is probably an hour and a half from here, usually they're going to have him back in that county within a week if it follows their normal course. They're just slightly above. Fort Gaines is across the river from Eufaula. So it's pretty close to us. Okay, but he's got to sign the waiver in the presence of a judge. So do you want him to go ahead and sign the waiver so that clock starts ticking? Because they have that time limit doesn't begin until he signs that waiver in the presence of a judge.
How long do they have?
By law, they have 30 days, but they've never taken that long. In fact, 15 days is just a catch to kind of make sure things are on track. I've never even seen one at 15 days from this county. It's almost as good as Dothan. Dothan's going to pick them up within 2 or 3 days normally. Right. Mr. Peter, are you okay with that?
Yes.
All right, so there's a waiver of extradition there. If you want to go ahead and sign it, then I'm going to ask the jail to notify them today that Mr. Peeler has signed the waiver, Corporal, and let Mr. Peeler know their response, please. Mr. Peeler, if they follow their normal practice, and I can't tell you a specific time, I can just tell you their normal practice with that county and that part of Georgia is probably 2 or 3 days. But I obviously can't promise you that. Under Florida law, they have 30 days. I don't ever let it get to that point without reviewing the case. So if you're still here in 15 days, I'll see you. That's highly unlikely. In all likelihood, Mr. Peter, they're going to either say we're not coming to get him, which would contradict what they said yesterday, or they're going to come get you within a couple of days, and you can deal with this once you get up there. The other thing that may happen, I know Mr. Green, I don't think you're licensed in Georgia. Mr. Green may have a contact in Georgia that might get them to set a bond up there. If the judge up there sets a bond, then you can post it and be released.
Yes.
But right now, the clock has started ticking on them today. Mr. Peter, do you have any questions?
No.
Mr. Green, anything else? Yes, sir. I don't think Georgia's not like Alabama. In Alabama, they have to be physically present in the state to post bond. I'm pretty sure Georgia, if they set him a bond, he can post it here without going up there. Okay. All right. Thank you. Wish you the best, Mr. Peeler. Thanks, sir. Next case we have friends or family here for Mr. McDaniel is Mr. Cook, John Cook. John. Mr. Cook, good morning. You're here on the page up here, Mr. Cook, for no motor vehicle registration where you signed a notice to be back in court and then didn't show up. Mr. Cook, you have some relatives in the courtroom on your behalf. Mr. Cook, I believe that your family, I'm not sure the relationship, your mother has produced a registration for Mr. Mitchell this morning. So I think Mr. Mitchell may have an announcement in your case.
Yes, Your Honor. The valid motor vehicle registration has been provided to the state. So at this time, the state will announce a no information on the record, and a no information has been filed in this case.
It's already been filed?
Yes, I went ahead and filed it.
So Mr. Cook, Mr. Mitchell's dismissing the case against you based upon that registration. He didn't get it until today. But you need to understand if you get a notice for court date, you don't have the option of just, you got to make sure you're here when that notice is for, and you had a handwritten notice for yesterday.
Yeah.
And that's why you spent the night in jail, because you didn't show up in court. But the case against you has been dismissed. Mr. Cook, do you have any questions?
Yes, sir.
Family have any questions? So he'll be processed out. Usually that's a 30-minute process. Y'all can pick him up at the jail. Here. Mr. Cook, hang on just a second. Mr. Cook, I think you have a civil infraction, but it wasn't the same day and time. So you need to understand, if you don't take care of that civil infraction and your time's running out on that, then your license is going to be suspended. I'm just making sure you're aware of that, Mr. Cook. You understand? You know what I'm talking about, right?
I don't.
You got another ticket after this one. You got a ticket for what, Mr. Mitchell?
It is failure
Like
to
fair
have,
use due care or something like that?
failure to have vehicle under control.
You got a citation for failure to have vehicle under control that you've not paid. Does that sound familiar to you?
All right, yes, sir.
Okay. If you don't pay that, your license is going to be suspended. And your time is running out on that. You received that in early December, and you have 30 days to pay it. So your time's running out. So family, you understand, he obviously didn't even remember it, which is very concerning. He forgets his court date. Now he doesn't remember a ticket he got. So, there may be some other issues y'all got to deal with. Okay. Wish you the best, Mr. Cook.
Yes, sir.
That's it for people in the courtroom, friends or family. Mr. McDaniels, we can go back to the top of our docket, which is Diego Alejandro Garza. Mr. Garza, good morning. Mr. Garza, you're here because you've been accused of one count of aggravated battery. Mr. Garza, there is probable cause in the complaint. But I've read your criminal history this morning, sir, and it appears to show no prior criminal history. Mr. Garza, that means, according to what I've been provided, you've never been arrested or charged with a crime anywhere. Is that accurate?
Yes, sir. I've never.
Perfect, perfect, Mr. Garza. So let me see what additional information the attorneys have. Then I'm going to address your bond or your release status. Mr. McDaniel.
I don't have anything, Your Honor.
Mr. Mitchell.
Nothing at this time, Your Honor.
So, Mr. Garza, when I read the complaint, I think it's aggravated battery because of the severity of the injuries. Apparently, there are some spinal cord or some spinal, maybe not spinal cord, some spinal column injuries, some, what do you call it?
Contusions?
Vertebrae, broken vertebrae. I don't know that, I don't know the results of it. The complaint doesn't give us a lot more information. There are two witnesses that basically say you were acting in self-defense, but at least one of them contradict your version. So this kind of all plays into the signing of the warrant. Your version is you struck the person one time. I think your own relative says that's not accurate. You struck the person multiple times. So there's some nuances there. Of course, his version, the alleged victim's version, is he was struck from behind. None of the other witnesses say that. So, Mr. Garza, your no criminal history really helps you. Let me ask you a couple of questions, though. How old are you?
I'm 21.
Okay. And are you a student or are you employed or neither?
Neither.
How do you live? If you're 21 years old, you don't have a job, you don't go to school, what do you do all day?
I help around the house with. I live with my mom and my stepdad, and I am in the process of looking for a job.
Is there any reason you don't have a job? Is there any kind of disability that prevents you from working?
No, sir. I've been we haven't really had a car for a good bit, so I haven't been able to go back and forth from jobs.
Okay. All right. So, Mr. McDaniel, Mr. Mitchell, what I think I'm going to do in this case is based on his criminal history, his lack of employment, I'm going to set him a misdemeanor bond or the equivalent of a misdemeanor bond based upon, it appears there may be some defenses to this charge. I'm not sure. Obviously, I have very limited information, but there are serious injuries. So, Mr. Garza, I'm going to set you a $2,500 cash or surety bond based upon the allegations against you. You do have a condition of no contact with the alleged victim. Mr. McDaniel, is there a request for a cash bond in this case, or you prefer the cash or surety option?
Cash bond, Your Honor.
Mr. Mitchell, any objection?
No objection to it.
Okay. So what that means, Mr. Garza, is you can post a $250 cash bond. You don't have to go through a bondsman. Your bond is $250 cash. When that cash bond is posted, you'll be released. You don't live in the same home with the alleged victim, correct?
They did.
We did at a time, but he moved out.
Okay, so he's been gone as of when? Yesterday or weeks ago or what?
Weeks ago.
Okay, so you can go to that home, just have no contact with him. Mr. Garza, you'll get to use the phone in a few minutes, sir, to try to post that bond. I'm also going to ask the jail to give you a notice for your court date. Your court date in circuit court will be February the
3rd, I think. Yep.
February 3rd at 8:30. Mr. Garza, do you have any questions?
What was the last thing you said?
February 3rd.
Before that.
February 3rd at 8:30. They will give you a notice for that day.
That's all, Your Honor.
Got it.
All right. Wish you the best, sir.
Thank you so much.
Yes, sir. Andrika Barnes. Ms. Barnes, good morning. Ms. Barnes, you're here because you've been accused of one count of robbery by sudden snatching. Ms. Barnes, I've read the criminal history. There is probable cause for the charge, ma'am. There's also, I've had a chance to look at your criminal history, so I'm aware of your not several, but multiple prior arrests that you have. So, Ms. Barnes, I think you're entitled to a bond. As far as I can tell so far, let me see if the attorneys have anything to add before I set that bond. Mr. McDaniel.
Your Honor, I'm not familiar with the past history. I did read the complaint, so you just asked the court maybe for a cash bond.
Okay, Mr. Mitchell.
If she's wanting to pay a cash bond, we have no objection to that.
Ms. Barnes, I'm going to do the same thing I did with the last gentleman. I'm going to set you a $250 cash bond. You have a condition of no contact with the alleged victim, which I believe is your mother. Is that right, Ms. Barnes?
Yes.
Okay, so what that means is if you post the bond or when you post the bond, you can have no contact with her. You can't go to her home. You can't live in that home. You can have no contact with her. If she wants to have contact, we'll cross that bridge if that happens. But she's not here today asking for contact, so I have to assume she does not want contact. She may, I don't know. But if she does, we'll cross that bridge. But you can have no contact with her until a judge authorizes it first. But in the meantime, you've got the right to post a bond. You call anybody you want to try to post a bond, except her. You cannot contact her about posting the bond. Ms. Barnes, do you have any questions?
Like all of my stuff is there. My purse is there. Everything is there.
Okay, so
I mean,
you can get that stuff. There's a way to get that stuff. Mr. McDaniel would talk to you about that, but you cannot contact her. And we need to give a notice to appear to Ms. Barnes for February 3rd at 8:30. Ms. Barnes, do you have any questions? The last case on the first appearance docket is Jeremy Booth. Mr. Booth, good morning. Mr. Booth, you're here for first appearance because you've been accused of one count of driving under the influence and one count of refusal to submit to a breathalyzer exam. Mr. Booth, there is probable cause for the offenses. Mr. Booth, I'm going to appoint the public defender's office to represent you for first appearance purposes. Listen to Mr. McDaniel, and he's going to tell me where we're going this morning. Mr. McDaniel.
Your Honor, I spoke to Mr. Booth. At this point in time, we're going to plead no contest to the charges as listed. You understand, he'll be sentenced to 4 months in county jail. Both of them run concurrent. The refusal may be a 60-day sentence, but it'll run concurrent with the 4-month sentence. $1,078 in fines. He signed his plea waiver form, waiving his right to jury trial and call witnesses, and that'll resolve this case today.
Thank you. Mr. Booth, the uncertainty with the refusal is because that's a relatively new crime. For years, refusing to submit to a breathalyzer was not a criminal charge unless you had a prior refusal. That changed, I believe, July 1st of 2025. So our uncertainty is it a first degree misdemeanor or a second degree misdemeanor? We've had 1 or 2 of these cases since then, but not many. Let's look it up and see what degree crime it is, Mr. Booth, and we can probably, well, the officer didn't put the statute number on there. Wow.
No.
Yeah, here it is. Here it is. He put on, it's on the other page. 3/16/1939. Mr. Mitchell, do you know?
I think it is a second degree misdemeanor for first time refusal.
How confident are you of that?
What's that statute again?
I'm
I can pull it
95%
up.
confident of that also, but
1939.
Let's see. The refusal to submit to a lawful test of his breath or urine is a misdemeanor of the first degree. It is a first degree misdemeanor. Hang on. Yeah, it's a first degree misdemeanor. So if you enter this plea, you're gonna be sentenced to 4 months in jail on each case, but they're running concurrent. That means they're running at the same time. So it's 1 4-month sentence, essentially with credit for the time you serve. Mr. Mitchell, is that agreeable with the state?
That is agreeable with the state, Your Honor.
Mr. Booth, any questions about that agreement, sir?
No, sir.
Mr. Booth, is that the plea you would like to enter, sir?
Yes, sir.
All right, Mr. Booth, I'm going to accept your plea of no contest to those 2 charges, driving under the influence. That's as a second offense. Refusal to submit to a breathalyzer. First offense, the judge is guilty of both those offenses, sentence you to 4 months in jail on each case, concurrent with each other. $1,078 court costs and fines credit for 1 day that you've already served. Mr. Booth, You certainly may participate in the Public Works Trustee Program. I hope you do. That'll help you get quite a bit of gain time off of this sentence. If that interests you, just talk to the jail staff about that after first appearance. Mr. Booth, do you have any questions about your sentence?
No, sir.
Wish you the best, Mr. Booth.
Your Honor, I did want to point out in subsection E, it does say first time is a second degree misdemeanor. So
I'm pretty
yeah,
sure
we
it's
may
the
have to clean that up.
Okay, hang on a second then. So in subsection D, it says,
E.
hang on just a second, Mr. Mitchell. In subsection D, above that, it does say second degree. Where did I see first? Oh, it says subsection D, it says first, but that's if they have a prior refusal. So if there's no prior refusal,
Second degree.
it's a second degree.
Yes.
It's a second degree for a first refusal or a misdemeanor of the first. Wow, that's a mouthful there. Okay, so what it says is, who, comma, after having been so informed, comma, refused to submit to any such test when requested to do so by a law enforcement officer or correctional officer, commits a misdemeanor of the second degree for a first refusal or a misdemeanor of the first degree for a second or subsequent refusal. Okay, so it's actually a second degree misdemeanor. So we need the disposition to reflect, thank you, Mr. Mitchell, that it's 60-day jail, it's 60-day jail sentence on the second degree misdemeanor first offense refusal. That's the maximum he can receive on that charge. The other charge will be the 4-month jail, so they still run concurrent. So we're going to correct that on the disposition, Mr. McDaniel. Thank you, Mr. Mitchell. Mr. McDaniel, that's everything I had on my first appearance list. Anything else from the jail this morning from the public defender's office?
No, Your Honor.
All right, we are back. We've procured the services of Ross Truckee for 2 sentences here this morning on a Wednesday. Abigail Stoll is with us from the prosecutor's office. We have one matter set at 10:30 and one set at 11. So we're going to get right to our work. Where we are doing, what we're working on is People versus Caleb Brian Stainer. There are 2 files, 252330SM and 252434FY. As I indicated, Ross Truckee is here with the defendant and Abigail Stoll. The defendant entered a plea which resolved both of these cases. On November the 14th, he was charged with domestic violence and malicious destruction of personal property. The complaining witness in that case was Maria Baldridge. Miss Baldridge and Mr. Stainer have 2 small children together. Defendant spent 4 days in jail on that case before posting a bond. Bond was posted on November 17th. Defendant was arrested on, November 17th. He was arrested on the 13th. Then, a few days later, on November 26th, the defendant was charged with home invasion, second degree, illegal entry, aggravated stalking, and interfering with a crime report. As part of a joint, in that case, he spent 10 days in jail. He was in jail from November 26th to December 6th. And then he posted a very large surety bond. Pursuant to the plea agreement, defendant pled guilty to malicious destruction of personal property less than 100. In file 252330 and to domestic violence and illegal entry in file 252434FY. All the other charges were resolved. The felony charges were dismissed. As I would usually do in such a case, I continued the matter to get more information and get input from the victim. So we've set the matter for today. I didn't get any victim input. According to Ms. Stoll, the prosecutor hasn't had any additional input from the complaining witness, and we're ready to do sentencing in these two matters. Mr. Truckee, what would you like me to know?
Thank you, Your Honor. Mr. Stainer. Mr. Stainer is 26 years old. He's employed full-time at Bill's in Bronson. He's from that area. He's residing in that area with his father now since these instances.
Which is where?
Bronson.
Okay.
My father's house or?
Yeah, your father's house.
It's in Billings.
Borough, okay. I know where Bill's is. I haven't been there a long time, but what do you do there?
I am one of the more common broil cooks. I usually work on the broiler. So I
make lots of steaks.
I do. I mean, hundreds, maybe if not 1,000 a week.
All right.
So he's working there in that environment. He's got a 5-month-old and a 23-month-old, both of whom are sons in common with the complainant here. Complainant's 22 years old. It appears to me as an outside person that these are two relatively young people with two very young children and too much alcohol in their house. Both of these had alcohol as a component. Mr. Stainer recognizes that had alcohol not been involved, likely these would have resolved in a different way other than a shouting match, screaming match, domestic violence conviction, and everything else. Mr. Stainer was exposed to domestic violence as a child, and I believe he's now cognizant that that affects how he responds when presented with intermarital conflict. And that's something that he would be working on to resolve. As well, the alcohol thing. He's got here with him a few chips that he's earned since his second arrest.
What are they? 30-day, 10-day, 30-day?
It's the blue chip is for showing up the first time as the initial, and then I just yesterday at class I got my 30-day chip.
All right, well, that's a good start. People have given some of those to me over the years, my little treasure box. But all right.
He's continued to attend after his release from jail, which is really what counts to me. When you're in the jail, not much to do. And so getting out for a meeting's fine. But he's maintained that in Bronson. Had a local church since then. And I believe that has kind of helped his overall personhood. So his criminal history is limited. He was charged with an assault and battery with an acquaintance who Your Honor is familiar with. I'll not use his name unless Your Honor wants it, but that was dismissed at a later time in 2022 or thereabouts. Outside of that, there's not a criminal history to speak of. He's been compliant with his tether this entire time. I think that the main thing in this case is we have somebody that's 26, which I'm getting older, but that's on the edge of what I would call young. Okay. And that is definitely the time where put up or shut up in life starts to happen. And this
tomorrow we'll either do Edge of 17 or 18 by Alice Cooper.
I'd go with the Alice Cooper song,
right.
Judge. I saw him in concert and it's stupendous. But the quote he gave to me was he never had something kick me in the ass like this, because this is the time where it's like, am I going to live this DV drunk, bad example for the kid's life, or am I going to put it together and be a man? And I am hopeful that Caleb is going to be a man now. And this is the time for that. So I'm asking that the court sentence him to a term of probation designed to continue his sobriety and treatment and help him resolve the issues that led to this incident and help him find what healthy relationships may be and what is okay and what's not okay and how to handle that marital stress. Thank you.
All right, well, who's in the Fawn River Road address right now?
Mariah.
And it's your father's house?
It's not his house. It's okay. So he has a friend from a long time ago. His name's Scott Plank. He lives 2-3 hours away from here. My dad oversees the property.
All right, so he's the property manager for the owner.
Yes, that's Your Honor.
All right, and I don't know if I have an estimate of the door jamb got broken, if I have a damage estimate.
I don't know if it matters, but I did put a new flange on the door and I did fix it when I got out of jail.
All right, well, that's relevant to me. Now, you've got two very small children, very close together in age.
Yes.
Does she have help with the kids? Are her parents nearby or your parents?
Her parents are not. My family does help quite a bit. Her grandparents help out here and there, but my family takes.
So right now she's at home with two very small kids.
Correct.
And at Christmas, you weren't able to have any contact with
No,
each other.
my mom, she did release them to my mom on the 24th for Christmas Eve, and I got to see them for a couple hours, but it's been pretty limited other than that. I had them the week that I was here, the 16th, and then I didn't have them for another week. Then I just had them again for about a week. So it's kind of week on, week off through my parents. They're going and getting them and bringing them to me.
Well, that's the best you can do under the no contact circumstances. Ms. Stoll, Mr. O'Bear and Mr. Truckee spent a lot of time on this, worked out this plea agreement. I'd hope maybe to hear from her, but what's your input here?
Well, Your Honor, the defendant may be young, but he is still old enough to know better than to assault the mother of his children. What especially concerns me is his actions in the felony file. He violated the conditions of his bond, showed back up at the house where she was staying, the victim. According to the police report, she tried to run away from him. She was running across the yard and he dragged her back towards the trailer. And at 26 years old, that's certainly old enough to know better than to treat anyone like that. I do believe probation is appropriate. I would recommend a lengthier term of probation, possibly 24 months, but ultimately I would leave it to the court's discretion.
Now, you didn't move into this house till July of 2026 or 2025?
Yes.
So you had two kids, but you didn't live together?
No, we lived together. We were.
But you lived in a different place?
Yeah, we just came up on the trailer and it was a lot better for the kids, so.
Now, depending on which version you believe, she was mad at you because what you were doing on your phone, or you were mad at her for what she was doing on her phone. And as your lawyer said, alcohol was a factor here. I don't know that she ever sent in her victim input stuff. So you guys are gonna have to figure it out. You got two small children, you didn't get married, so she has paramount parental rights. I don't know what her position is regarding allowing you back into the home. Normally, when I do a probation, I lift the no contact provision. So let's do the malicious destruction of property case first. That's the November 13th case. The domestic violence charge in that case was dismissed. You spent 4 days in jail in that case before you posted the bond. There's a $75 crime victims' rights fee and a $50 state minimum fee and a $55 fine, which equals $180. You posted a $2,000 10% bond. You posted $200. The court keeps 10% of a 10% bond, so there's $180 to apply to your fines and costs. I'll reserve on restitution. That probably isn't any. You fixed the door and your father's the property manager. But if there is, I can always amend the order and allow it. That takes care of the 13th matter. Now, the next one. Ten days later. And obviously the prosecutor was quite concerned about this. There were bond conditions of no contact, which you violated. Who are Jason and Samantha Stainer?
Those are my parents.
All right. She stated Caleb was at her house when she got home, that he kept driving by, leaving and coming back. She kept asking Caleb to leave, but he would not do so, at which time she left. When she came back, Caleb was gone, but then he returned when he saw her vehicle back in the driveway. Caleb entered the residence through a front door, which does not lock, and came into her bedroom, grabbed her by the head using both hands and hit the back of her head on the bed frame multiple times. She had bumps on her head. According to Baldridge, Caleb held her down by her arms with her legs and punched her in the face using a closed fist. Baldridge stated that Caleb told her he would beat her ass. He would give her a reason to call the cops. Took the phone from her. I mean, that's bad. She had to run out and call for help. They arrested you like over at Bronson later that night. So there's no mention here about alcohol, except it should be noted for medical reasons. I asked Caleb on a 1 to 10 scale how drunk he was, and he said a 3. Caleb said she was drunk, but I just came from Baldridge and she did not note any signs of intoxication. And you came home. Anyway, alcohol was a factor, but you weren't even supposed to be there. She's got a 3-month-old child in the house. She doesn't have time to be out driving around. By the time they finally caught up with you at the jail, your blood alcohol was 240. So this case also includes a bunch of drunk driving, where you're driving around here in Branch County while you're drunk. And you got 30 days sober. I guess that's a good start. If you're both drunk, I don't know who's taking care of these very young children. But you don't just get to that high of a blood alcohol level without building up a tolerance. For you, a 2-4 is a 3 on a scale of 1 to 10. I hate to think what you're like when you get to a 10. Of course, when you're drunk, you're not the best judge of how drunk you are. On the illegal entry charge from the second incident, or 10 days credit, 10 days. Concurrent with a domestic violence case. Zero fine and costs. I had really hoped to hear from her. I'm not sure what she feels about the no contact provision or how she feels about this. She also bit you. I mean, it's just bad. As Ms. Stoll said, you guys are old enough to know better than this.
I have advised my client that through my work in the family courts, this is the kind of situation that leads to foster care.
Yes,
So
it does.
I think that has also been made clear to him.
All right, on the domestic violence charge, what do I do? I don't like the fact that you were on a bond with no alcohol and no contact and no assaultive or threatening behavior. You went out and did exactly the things I told you not to do. And according to her, you punched her in the face. You were 3 times the legal limit to drive a car, plus you're driving a car around drunk. One option is just give you 90 days in jail and see how you like that. That makes you lose your job. This deserves 90 days or more in jail. We set a very high bond, $30,000 cash or surety, was reduced from a felony to a misdemeanor, and then the bond was reduced accordingly. But I think you posted a $30,000 bond. Did you post a bond through a bonding company?
Yes, sir.
You had to put up $3,000?
$1,800.
What's that?
$1,800.
And that's all money away from your family.
I just made my first payment on the bond today.
Say that?
I said I have to make my first payment on the bond today.
Prosecutor's asking for 4 months probation. I think that's appropriate. You can be discharged at the end of 12. It's to be determined whether you're eligible for a deferral. I'm going to send you to the DV class, the full class. No drugs and no alcohol, no assaultive behavior, no marijuana. Do you use marijuana?
I do not.
I'm going to sentence you to 90 days in jail. Credit 10. Of the 90 days, 80 are deferred. It won't take much for me to pull the pin and just give you the balance of the jail. So I want you to comply with the terms of this probation.
Yes,
Fines are 0. You got enough to pay. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $960 probation oversight fee, which could be cut in half if you do it in 1 year. You had to pay for the class. The deferral is to be determined. I can't do a deferral in a domestic violence class without the prosecutor's, in a domestic violence case, without the prosecutor's consent. And we'll put you in the program and see how you do if you complete the domestic violence class successfully, and otherwise complete the probation. I'm sure the prosecutor would agree to a deferral. If you don't, then this will show on your permanent record. I'm going to leave the no contact provision in place until further order. I have two options: lift it and have her request me to put it back, or leave it in place and have her request me to lift it. But I don't want to lift it without input from the complainant. No contact remains in effect until further order of court. You are communicating between intermediaries, and that's good. You guys have done about as best as you could through the holidays. But she's never returned any contact from the prosecutor's office. And I would ask whoever your intermediaries are to direct her to contact the victim advocates at the prosecutor's office or the probation department, and I can determine what to do with this. If you don't have any, or you're not married, and you don't have a custody or support order, who's paying all the bills?
Just when I have the kids, it's on me, that type of deal.
Well, who's paying the electric bill, the gas bill at the address?
I'm not sure what she's doing. Last I knew, she was trying to move out of there. So, I do know that she's a couple months behind on the rent. Because when I was there, I took care of a lot of that.
Well, so now that you're not there, you don't have to pay rent anymore. Well, that's a good deal.
I pay my dad, but correct.
And your two kids are a half a step from homeless. So you don't know who's paying the propane bill or the electric bill?
I do. I would assume she is.
Well, what does she have for income?
She is a server at Judd's Barbecue in Angola.
Who watches the kids while she's at work?
Right now, with all this going on, I'm off during the week because my work didn't want to put me on all my hours. My mom takes them quite a bit, and my dad also watches them.
She got a 4-month-old baby and she's working as a server and 45 minutes away?
Yeah, she works 5 or 6 days a week. She makes okay money. But like I said, I wouldn't know for sure what her financial situation is exactly.
What to do? We need a probation here. Yeah, it's like I'm dealing with two 18-year-olds. All right, I'd like to hear from her. All right, you're on probation on the domestic violence charge. No drugs, no alcohol. Test as directed. No assaultive or threatening behavior. They could also use some substance abuse counseling. I'd like you to stay plugged into AA. No contact remains in effect unless I hear from her, in which case I can lift it. At least you can talk to each other. Whether you're going to move in together, I don't know, but and you're lucky you didn't hit a tree or something in the meantime. This does not affect your driving privileges, even though you were driving around 3 times drunk. I want you to go down to the probation department and get plugged into that. I will say your attitude has been pretty good. As Ross said at the time of the plea back in December, you're like, okay, I owned it. I accept responsibility. I don't like you punching her in the face. I don't like you going over there in direct violation of my orders. But let's see if we can make something out of nothing here. Otherwise, you'll end up in jail for a while, 80 days. All right, you go down to probation. I will reserve on the deferral question.
Thank you, Your Honor. Thank you, Your Honor. Thank you, Ms. Fuller.
All right, another quality human being has shown himself here on TCF Live. Let's move away from judges for a minute and go to Louisiana. Let's see what's up with the board today.
Right now, so if you would correct that, we'll get started. If you can hear me, I'll go for my preliminaries. It's 8:40 in the morning. Today's date is the 8th day of January, 2026. We are in the headquarters of the Department of Corrections in Baton Rouge. My name is Steve Prater, and my board members this morning are Jerry Ledoux on my right and Chuck Tillis on my left. Chuck Tillis will be handling the questioning today about the revocation hearing that we'll be hearing. Staff, would you introduce yourselves, please?
Jessica Thompson.
Ben Cavalier.
Carla Williams.
And Francis Abbott.
Okay, and we are talking to Mr. Renwick Jackson, and y'all are at Ouachita Parish Correctional Center. Is there any staff in the room with Ouachita Parish?
Yes. Yes, sir. Good morning, Deputy Marchand.
Okay, thank you. And who else is in the room there? Would you introduce yourselves, please?
My name is James Ross. I was the attorney who was appointed to represent Mr. Renwood Jackson on the charges. And of course, we have the investigator for the Injured Defendant Board, Tammy. Introduce yourself.
And my name is Tammy Jordan.
Okay. Well, thank y'all for being there. We appreciate it. And we'll go ahead and get started with this hearing then. Excuse me, sir.
Before you start the hearing, I'm not quite familiar with all the rules of the parole board. However, I was appointed to represent Mr. Jackson before the court, the 4th District up here. And then this matter as well came up. Now, we had a hearing which was scheduled for yesterday here at the 4th Judicial Court before Judge Mannings, the district court judge, to determine probable cause. But the DA who was supposed to be present was out because of the flu. And, I am sure that there was no probable cause to bring the charges against Mr. Renwick in the beginning, which would have been brought out on yesterday, but for her sickness. I brought a motion since I just found out about the hearing that because of her illness, and I was tied up with Judge Manning all day yesterday. I drafted a handwritten motion for a continuance of this matter until Ms. Jones, the prosecutor, had returned for the probable cause hearing. And our witnesses, the judge had ordered that our witness not be brought in until after the probable cause hearing, which has been moved to next month. So I would like for this body to consider continuing this matter until after the probable cause hearing. And I wanted to file this motion. I was advised just to bring the motion to the hearing. And that's what I'm seeking today until Judge Manning rule on the probable cause hearing.
Okay, we appreciate that. We understand that, and you do understand, I would hope, not to discuss a lot of legal things because I'm not nearly as knowledgeable as yourself. But we don't deal with probable cause on our committee as well. We do a preponderance of the evidence is what we have to have. And so therefore, it's up to the board and my members. It's not just up to me about whether we continue it. But we don't necessarily need a guilty conviction to revoke. And the only time that really a guilty conviction has anything to do with the revocation is we automatically revoke on conviction of a felony. And so that's other than that, I'm not prepared to discuss the legal matters with you because I know you whoop me pretty quick. And so all I know is what we deal with on this board. And so I guess I would like to ask the board, is it your desire to continue this or to?
We have other matters before us, not related to the actual crime of failure to register that we need to deal with. So there are other issues of parole conditions.
Okay, so we will go forward. Is that okay? It's the desire of the board that we continue with this hearing, and you're welcome to step in and you'll be able to make a statement or whatever for the record. But we're going to go ahead and continue with this hearing and see what the outcome is. Okay, we're talking to Mr. Jackson. Would you tell us what your DLC number is, please, sir?
DLC number is 122349.
Okay, and do you have a revocation waiver in front of you that you signed?
Yes.
Piece of you signed?
Yes.
Okay, and you signed that, and you do have an appointed counsel. The appointed counsel is present for purposes of the record. Having said that, I'll turn it over to Mr. Tillis to talk about the violations, the suspected violations of the conditions of your parole.
Good morning, Mr. Jackson. I'm going to ask, you have three violations that three rules that you violated. You can answer guilty, not guilty, or guilty with a statement. Not guilty with a statement. Rule number 4, on 8/20/2024, you were arrested for committing the offense of failure to register as a sex offender. You had an unregistered social media account actively in use on your cell phone. The next court date for this pending charges is on 1/7, which you explained, your attorney explained. How do you plead on this? Guilty, not guilty, or with the statement? Not guilty with the statement?
Yes.
Okay. On 8/20/24, you were untruthful when asked about your social media account on your cell phone. How do you plead on that? Guilty? Not guilty with the statement, or
Not guilty with a statement, sir.
okay. 10, you are in the rear of $1,312 supervision fees. How do you plead on that? Guilty or not guilty?
Actually, not guilty.
Not guilty.
Yes, sir.
Okay. All right, rule number 4, what happened? Tell us about that.
Rule number 4?
You didn't register as a sex offender.
Well, I didn't.
Can we speak on that?
Sure.
All right. I asked Ms. Tammy to explain that so that you have a clear understanding of what's going on.
Okay, I honestly did not think we were gonna have to do this today. So I don't have my West Law book with me. But although on the arrest record, that's what the probation officer put. But if you'll look, there's some letters after, I don't know the RS code for failure to register as a sex offender. off the top of my head, but after the number, the RS code number, there's going to be some letters and a number. So if you go down to that paragraph in the law book, he's never failed to register as a sex offender, but there's some paragraphs, some sub-paragraphs under that law heading. And it had to do, that paragraph that he was charged with has to do with having a social media account, which is not against the law anymore. You can have a Facebook and Instagram and all that, but when you have the Facebook, let's just use Facebook because that's why we're here. You have to have a banner on your homepage. And are you all familiar with Facebook and what it looks like? Okay, so on your homepage where it has your picture, your name, your real name, not a nickname or anything, has to be on that home screen on a banner, and you have to have your number. And I'm assuming that means the DOC number. I'm not sure about that, but you have to have your real legal name and your number on that banner, and you have to say, I'm a registered sex offender.
Is that on the account?
Sir?
Is that on his account?
He doesn't have an account. He doesn't have an account. He's never had an account. This gentleman sitting in front of you has never even had an email. Now, I don't know how much I need to say today. I feel kind of uncomfortable because we haven't told the judge this information. And we weren't having a trial yesterday. We were supposed to be having a preliminary examination of the evidence that to see if there was enough reason for it to be probable cause to even arrest Mr. Jackson.
I think we need.
Of course, we didn't get to do that because.
Okay. Before we go into executive session, it's D1 regarding social media.
That's correct. I don't trust myself. I don't trust my numbers, so I didn't want to say, but yes.
Thank you for your input. And the time is 8:50 right now. We have a motion by Mr. Tillis to go into executive session and a second by Ms. Ledoux. We're going to briefly go into an executive session to discuss a procedural matter. And then we'll be right back, probably within just 2 or 3 minutes. We'll be back in touch with you.
Okay.
Yes, sir. Thank you.
Michael just summed it up in the chat when he said, what a weird case. Yeah, exactly. The idea that his legal representation is like, well, I didn't prepare because I didn't think we'd be doing this today. What? I put in the chat, I hope this guy's not paying for this legal representation. If he is, he's getting ripped off. You got to be prepared for all eventualities, not just do half the work. But that's just my opinion. You let me know if you think differently in the chat. Let's go briefly up to Judge Simpson, where we'll hear some bonds continue while we wait for these guys to get out of their executive session.
January 29, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls
right
case
there,
of the
bond
people
continued.
versus Christopher Thaxton.
Hey, Your Honor.
James Fifelsky on behalf of Mr. Thaxton, who is approaching.
Your name, sir?
Christopher Thaxton.
Thank you. Your Honor, all discovery is in, and we would ask the court to set this for a preliminary examination.
Two other witnesses available the 20th.
That's fine.
Preliminary examination will be set January 20th, 2026, 9 a.m. before Judge Moore. Bond continued. Thank you.
Thank you, Your Honor.
Stop. Court calls case people versus Rick Artuso. Right here. It's another Ballinger case. He's asking for an adjournment, so.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Artuso, Your Honor.
Mr. Artuso, can you state your name, please, sir?
Rick Artuso.
All right, he's waiting a response on this. What I will do, turn the matter out to January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Artuso.
Okay, thank you.
Court calls the case, People versus Mark Tipsword.
And then on behalf of Your Honor.
Proceeds to substituting in for the Washington County Public Defender's Office, appearing on behalf and with Mark Tipsword.
And I've signed the substitute. All right, what are we doing?
Your Honor, may Ms. Senna and I approach, please?
Okay.
All right, good timing as they do their sidebar. Let's go back to Louisiana. Looks like they're ready to go.
We have been in executive session, and so we need a vote to go back into regular session. Do I have a motion?
Motion that we go back into.
Motion by Mr. Tillis and second by Ms. Ledoux that we go return to regular session, and there is no objection to that from me. So we're back in regular session as of 8:53 now. Okay, Mr. Tillis, would you continue?
Okay, we have facts that he does have an account. And so on the rules that we have, rule number 7, how do you plead on that? You are untruthful when asked on your social account. How do you plead? You said with a statement. Go ahead, attorney, if you want to say something.
And that's what the Miss Tammy was trying to explain to you, that this account is not his account, which appeared on his phone. I wanted her to get into the details. She is a retired Monroe police officer that's assigned to work with the Engineer Defender Board. We've gone through all the facts of the case, and we want to explain why there's no account. Mr. Renwick has no account, but how an account appear that you're referring to, you think that he has an account, but he does not have an account whatsoever. So if you just indulge us for a few minutes, let her explain that, you'll understand why.
Okay, go ahead.
Okay, do you have a copy, or are y'all familiar with the probation officer's report, his arrest report, where he talks about, you're going to see the words GUWOP was the name of the account. Are you familiar with all of that?
We've read it extensively, yes.
Yes, ma'am.
Okay, great, all right. Okay, so y'all know what I'm talking about. So they were in a meeting, one of their visits. He gets his phone, he opens it up, and he can see a Facebook app. So he opened up the Facebook app, and he said, he saw a black man in a shirt. I mean, it's a huge picture, you can't miss it. And it says, instead of using a real name, the name of the account was GUWOP. Okay, well, I want to show you. When I saw that report, I got on Facebook, and this is GUWOP. And this is a man by the name of Dex Patton or Payton. He lives in Bastrop, Louisiana. And Bastrop and Collinston, it's like a little community close to one another. People who live in Bastrop have friends in Collinston and vice versa. And a neighbor, if I can call him a neighbor of Mr. Jackson's, lived on his street in an abandoned house. The man was homeless. No running water, no electricity. And he would come down the street to Mr. Jackson's place, and Mr. Jackson would give him food, sometimes let him have water, whatever he needed, because the man had nothing. And so he would use the phone. You cannot have a Facebook account without an email. I mean, that's just, everybody knows that. This man has never had an email account, and I verified that, and I have written statements. And if we had known, well, this room's not big enough to hold all the people who know him. He's been incarcerated 2/3 of his life. He missed out on all the technology training that we all started with bag phones. I had a bag phone as a police officer. And as technology grew and our phones changed, well, we adapted with that technology. He missed out on all that. You cannot have social media without an email. That's one of the requirements when you're signing up. You have to have that. I verified he does not know how to do all that. With his brother, I have a written statement from his brother. I have the written statement and obviously interviewed them for extensively. The young man who lived down the street in the abandoned house. All these people were subpoenaed for court and willing and happy to come to court. And I now have an address to serve subpoena on Mr. Payton, and he will be there. And I don't know, can y'all see well enough that?
Yes, ma'am, we can see pretty clearly, believe it or not.
Okay, for me, it's not that great to be able to see y'all, and I read lips, and I'm not able to do that, so I'm kind of struggling. But right here on the screen, you can see where it says GUWOP, GUWOP. Look at the probation officer's report. He was so angry when he saw this, and Mr. Jackson kept telling him, please look at his statement to the probation officer. He said it over and over again throughout that 2-page report, over and over. That is not mine. I don't know how that's on my phone. I don't have a Facebook, is how he refers to it. So I have those two men. There's a friend of his in Lake Charles, her and her husband. She said, yes, Jordan, the only way I've ever communicated with Mr. Jackson is by talking on the telephone. He doesn't have social media. He does not have an email. She said, we talk. She said, he will text if he just absolutely has to, but he does not know how to do all that. He should have never had that.
Ms. Tammy, I just pulled up Facebook, okay? Renwick Jackson. This picture is exactly like the offender sitting before me.
Yeah, I see that.
I want you to know that we have spent hours on Facebook. We spent hours when we were putting this together, and there was no Renwick Jackson account. Now, do you realize that someone can't, ma'am, please, they can make a Facebook in my name. They can make a Facebook in your name.
Yes,
I'm like an idiot. I thought I was becoming friends with Keanu Reeves, and it was a fake Facebook account.
Okay.
You don't have an IP address, and they did not do a forensic download of that phone. You cannot prove that is Mr. Jackson did that. He can't do that without an email. You can't do that.
Do you have any? I don't have any more questions.
Okay, did we finish all the violations?
Yes, rule number 10. You said that you're in the rear of $1,312, and you said not guilty.
It's because you've been incarcerated.
Yes, sir.
He was paid in full up until the time of that he was reincarcerated. He was up to date.
And employed.
And employed at the time.
Okay,
Yes.
all right,
Garrett, yes.
all right.
Okay, do you have any questions? And I have no questions.
You're ready, I'm ready to vote.
Yes.
I'm gonna vote do not revoke. That's my vote for today.
Okay,
My vote is to revoke based on non-compliance with conditions of parole number 7.
And number 7 would be?
The social media, being untruthful about the social media.
All right. did you understand though, how that you cannot have a,
Excuse me, sir, we're voting and I'm sorry, but it's, time for the argument is really over.
right?
I
I just want to
hate
make,
to cut you off, but this is a little different. And my vote is to continue. Because I'm not satisfied. And so I'm going, put this in quite a dilemma that I've never been experienced. And because we have 3 separate votes. And so,
Okay, I'm gonna change my vote to continue. I think, until this is ironed out, you feel like you got proof we don't want to send an innocent person. And so my vote's gonna be to continue this as you asked.
okay,
Thank you.
back to square one, like the Mr. Attorney asked to begin with. We have voted 2-3, which all it takes on revocation is 2-3. And so therefore, this case has been continued as of 9:02 this morning. And you'll be hearing more from us as we continue to study this particular situation. 9:02, end of hearing.
May I say something else, please, on the record? Nope, cut us off.
Damn straight you got cut off. Oh my goodness. This, my friends, there's a bunch of new people out there. Welcome, by the way, to TCF Live. This is why you join us every day. You never know what you're going to come across here.
25 CR 1228. Are you, you're Kenlon Falk? All right, Mr. Falk, you were charged here in 25 CR 1228 with the 2nd-degree felony of aggravated assault with a deadly weapon. Do you understand? Which carries with it up to 20 years in prison. Because this was handed up back in September by the grand jury. And this goes on to allege, though, that you were convicted of robbery 2 times in the 252nd District Court on the same day, May 24th, 2002, long ago. After those 2 convictions were final, it is alleged in the indictment that you committed the offense of illegal possession of a controlled substance, a 3rd-degree felony, and you were subsequently convicted of that on February 21st, 2019, also in the 257. So if all of this is true, you are looking at habitual felon status, no less than 25 years, no more than 99 years confinement in prison or life in prison is what you're facing. You understand? So that's what the guy was facing yesterday in yesterday's trial, who got 55 years in prison. You are under arrest at this moment. Do you understand? So, yes, you are under arrest. There's a warrant for your arrest. And the police, the officers are going to get with you on this, and they will be able to talk to you about it. But this has popped up, and you got an answer for it. We're gonna make a copy for you so you can have a copy of it. But your bond is revoked due to this warrant. And what was his bond before? What was your bond on this?
I think it was 20,000.
20,000 for habitual felon and committing aggravated assault.
Judge, I believe the issue here is the case was filed and dismissed, and I believe he bonded out on that first filing. And when it was dismissed, there was no warrant, and he didn't bond out on the new indictment. So I believe that's what's happening today.
That's correct. He has no bond on this new indictment. So he's just make bond.
Fine.
So
I don't find this bond enough. At $25,000 anyway. Who set the bond? Bad. But you are a habitual felon, sir, and these are two prior violent crime convictions and then a serious illegal possession of a controlled substance. And now this is aggravated assault by threatening to use a deadly weapon, namely a vehicle. So your bond is increased to $100,000. There's a way to avoid all of this, is to not to commit crimes. And if you post a bond, you will be at home confinement. You must have a GPS device. You cannot leave the home except to and from work, most direct route possible, to and from hospital care, to and from acquisition of food. And those are the other purposes. And that's the way it is. Do you have an attorney?
Also,
All right. Are you unable to hire somebody? Fill out an indigent form and an attorney will be appointed to represent you. We'll appoint somebody today from the public defender. You're taken into custody. That's the rulings of the court. No, sir. Sir, your bond is too low. Sir, you are a danger to the community. Your bond is far too low under the circumstances that we have. Plus, there's a warrant for your arrest. And it's not a debate, sir. Follow the rules of the court. Thank you.
We'll just get up to fill out indigent form for the jail.
Next is Jaquan Lazard. Next is Bruce, Curtis Adams.
Yes.
You got that shot, I'll leave it.
And you were Curtis Adams.
Yes, sir.
Chris Ray.
Yes, sir.
23 CR 1728 is now called. Curtis Ray Adams, who's here with Mr. Smith, Bruce Smith, his attorney and the state's attorney. You were charged with the third-degree felony of operating a motor vehicle in a public place while intoxicated, and you have 2 prior DWI convictions, so it becomes a more serious crime, a third-degree felony. Does the defendant waive a formal reading of this indictment and arraignment to proceed itself?
Yes, sir.
In summary, paragraph 1 alleges that on or about December 23rd, 2022, in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. The second paragraph of this indictment alleges that you have 2 prior convictions in 2012, 2013, out of County Court at Law Number 2 of Jefferson County, Texas, for DWIs, or operating motor vehicles in a public place while intoxicated. Paragraphs 1 and 2 constitute a third-degree felony, which carries with it a term of not more than 10 years or less than 2 years in prison. In addition, a fine will be assessed not to exceed $10,000. Do you understand what we've discussed so far?
Yes, sir.
He was in.
An agreement has been reached with your attorney and the state that you would be pleading guilty to this offense. Whatever sentence shall not exceed a cap of 10 years in prison. And it says the defendant is going to request, defense is going to request probation. So we call this a cap, which has options. You could be sentenced to no less than 2 nor more than 10 years confinement in prison. You could be sentenced from no less than 2 up to 10 years in prison, and that could be suspended and you could be placed on regular probation for up to 10 years. And I think those are our options. Yes, sir. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
What we will do is enter pleas at this time, then have a pre-sentence report prepared. We'll come back later in a few weeks. Everybody gets to add additional information you want the court to consider, and then the court will make the decision. Okay. How do you plead to paragraph 1, charging you with this DWI, guilty or not guilty? Guilty. Are you pleading guilty voluntarily and because you are guilty? Yes. And paragraph 2, which alleges these 2 prior DWI convictions in 2012 and 2013 out of the County Court of Law 2 of Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
Are you pleading true and correct to those allegations voluntarily and because they are true?
Yes, sir.
Tell you what's marked with State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered in without objection. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know, it's been charged with an indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is tendered and made a part of the record for all purposes. All right, you're going to order a pre-sentence report and return back
February 13th.
February 13th, 2026, 9 a.m. And then we will determine what the appropriate resolvement as a Senate should be in this case. Please get a reset.
Thank you.
Silent here.
It's TCF Live on a Friday. I hope you're all having a good day so far. I know I am. Always good to be with you guys. And why do we call it a Super Friday here at TCF Live? Because regular Fridays are for normal people, and we're all extraordinary. So, quick programming note, starting Monday. So, yeah, just a couple days from now, this show will start an hour earlier, 9 a.m. Eastern, 6 a.m. Pacific. It will become a 4-hour show. The 4th hour will be a little bit different, though, than the first 3, so be sure when you're here with us on Monday to stick around for the 4th hour. Let's change things up. Let's go to Florida. Wade Mercer's first appearances.
Mr. Smith, good morning. Mr. Smith, you're here because you've been accused of 1 count of murder. It's a homicide charge. It's essentially an open count, which means at this point it hasn't been defined whether you're going to be charged with a first-degree murder or something else. Mr. Smith, I'm going to address your bond status this morning, but before I do so, I'm going to listen to the attorneys and see if they have any additional information. Mr. McDaniel, anything on behalf of Mr. Smith?
No, Your Honor.
Mr. Mitchell?
Well, he did turn himself. I will say, Your Honor, I guess he did go and turn himself in when he found out about the warrant. So just take that. I don't think it's a major flight risk.
Okay. Mr. Mitchell?
Your Honor, the state is reviewing about possibly filing a motion for pretrial detention. We may make that decision probably on Monday, but for today's purposes, we can just do a regular bond analysis.
Mr. Smith, I'm going to set you no bond to the nature of the charge, due to the nature of the charge at this point. Mr. Smith, that may change. But for right now, at least for the time being, it's as serious charge as we get. So you've got no bond for now. The prosecutor's office, if they think you're entitled to a bond, your attorney, either hired or appointed, will file an appropriate motion. But for right now, you've got no bond. Mr. Smith, do you have any questions?
No, sir.
All right, sir.
All right.
We do have friends and family here on the bit. Al Mateen. Mr. Almateen, good morning. Mr. Pittman is here on your behalf. He's just here supporting you and speaking on your behalf. You're here because you've been accused of 1 count of failed arrest your motor vehicle as a sexual predator within the requirements of Florida law. There is probable cause in the complaint. I'm going to listen to the attorneys, and then I'm going to set your bond, Mr. Mateen. Mr. McDaniel?
John, we just asked for a reasonable bond.
Mr. Mitchell?
Same, reasonable bond under the circumstances.
I'm gonna set your standard bond. I normally would set it for this charge at $5,000. Your bond's $5,000 cash or surety. The allegations are you've owned a vehicle since June, roughly, and haven't registered it. That is, that if that's proven, that would be a violation of Florida law. So that's the basis for the charge. So it's a $5,000 cash or surety bond. That means you can go through a bondsman. You don't have to put up all $5,000. That's what a surety bond would be. I'm also going to ask the jail to give you and Mr. Smith a court date. And I forgot that on Mr. Smith. That would be when, Madam Clerk? February 3rd. Please give both of them a court date for February 3rd at 8:30.
Yes, sir.
Court starts usually about 9 o'clock. We give notices for 8:30 and that'll be in the other courtroom down the hall. They'll give you that notice before you try to post bond. They'll give you that notice. Do you have any questions? Mr. Mateen, Al Mateen.
No, sir.
Mr. Pittman, you have any questions, sir?
No, sir.
All right. Wish you the best, sir. Thank you for coming, Mr. Pittman. Next we have, is Mr. Tappan, is he there this morning, Mr. McDaniel?
No, Your Honor, he's not.
The clerk made me aware this morning, or I was told this morning, that the complaint actually had 2 counts of battery, 2 different alleged victims. It was a little confusing because when you read the first sheet, it showed 1 victim, but there was another sheet under that. There was probable cause for 2 people, and I thought they just chose to charge 1. Apparently, there were 2 first sheets and 2 second sheets. Instead of doing 2 on 1 complaint and listing 2 charges, the officer chose to do 2 different, completely different complaint affidavits. So instead of 1 charge, there's 2. There's 2 alleged victims. So it's going to double the bond I set yesterday. So Corporal, please show whatever bond I set for him in 1 count. He actually has 2 of those, 2 different victims. And the condition, no contact with either of those people, and the bond will be twice the bond I thought it was yesterday based upon there being 2 cases. Any questions about that, Corporal? Thank you.
No, sir. Thank you.
Thank you. Next, we have Daryl Powell. Only have 2 more cases. Mr. Powell, good morning. Mr. Powell, you're here because you're accused of violating the terms of your probation. Mr. Powell, there's a no bond warrant in that case. I want to arraign you this morning, Mr. Powell, because I want to get you an attorney appointed if you want one. Mr. Powell, would you like to have an attorney appointed to represent you?
Like a paid one, or like, I don't got no money.
Just say yes, sir.
Yes, sir.
Okay, I'm going to appoint you a lawyer if you want one. And if you decide to hire one later, that's great. But for right now, I want to get you a lawyer. So we're going to appoint the public defender's office to represent you, Mr. Powell. Listen to Mr. McDaniel. We'll see if you have any questions in just a moment.
Your Honor, we're going to enter plea of not guilty. Ask to set this in the February 5th court docket, and I advise you that a public defender will come by and speak to him prior to that hearing.
February 5th, Mr. Mitchell, anything?
No, Your Honor.
And Mr. Powell, February 5th will be your court date. Mr. Green or someone with the public defender's office will see you before then. Do you have any questions?
No, sir.
Have a good day, Mr. Powell.
All right.
I think the last case we have is Anna Augustin.
Yes, Your Honor.
Miss Augustin, good morning. Miss Augustin, you're here because you're accused of 6 counts of petty theft or retail theft, 1 count of scheme to defraud. Miss Augustin, I've read the complaint. There is probable cause for the charges, ma'am. Miss Augustin, I show 1 charge that was allegedly occurred when I was 7 years old. That'd be 1978, and that case was dismissed. Have you ever had any other charges besides that old case that was dismissed?
None ever, no.
Excellent. That's great. Let me see if the attorneys have any additional information. I'm going to address your bond or your release status. Mr. McDaniel.
Your Honor, she's lived in Jackson County, I think, for 20 plus years. She owns a house here. I mean, she's 73 years old. She's not going nowhere. We'd ask the court to consider some kind of, or some kind of release option, show back up for court. It is what it is, but she's not going nowhere, Your Honor. And I don't think.
I have no place to go.
Thank you, Mr. Mitchell. Any input from the state?
No, Your Honor. We'll leave it to the court.
Ms. Augustin, I'm going to set you the normal bond I was set for these charges, but I'm also going to offer you a conditional release because of your criminal history. So the bond is $2,500 per misdemeanor, $5,000 on the felony. That would be 15 plus 5 is 20. $20,000 cash or surety is the bond. If you want to accept the conditional release, I'm glad to offer you a conditional release based on your history, ma'am. You will have a condition, no contact with any Walmart while this case is pending. It doesn't matter if it's the Mariana Walmart or another one. No, you can't go to any Walmart. The alleged victim while this case is pending. Ms. Augustine, I'm sure that Mr. McDaniel has already explained to you the difference between the conditional release and the bond, but do you have any questions about that, ma'am?
The conditional release is when I pay for the monthly charge?
You pay a monthly
Yes.
supervision and you have to report in once a week by phone and stay out of trouble and follow some other rules.
Okay.
Is that what you want to do?
Yes.
So what's going to happen, ma'am, is they're going to bring you to the courthouse because that's where the conditional release office is at. You're going to meet with one of the conditional release officers. Mr. Goodson probably will go over the release with you. He'll answer any questions you have, and then you'll be free to go. Ma'am, the jail's going to give you a notice for your court date. Your court date will be February the 3rd at 8:30 a.m. will be your court date. That's the day you have to be in court to see Judge Garcia. Ms. Augustine, do you have any questions?
No, I don't think so.
All right, ma'am. Wish you the best.
Thank you, Judge.
Thank you. So, Mr. McDaniel, I know there's one thing I want to talk to you about off record about an issue that I'm sending an email on. Hopefully we can get straightened out. But anything else from the public defender's office on record, Mr. McDaniel?
Short day for Judge Mercer. Let's head back for a few more minutes to Judge Stevens.
Texas versus Trent Sean Mixon. Is that you? Present with your attorney and the state's attorney. Does the defendant Mr. Gamble waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? He does. Okay. In summary, sir, this indictment alleges two parts, two paragraphs. One paragraph, the first one, alleges that on or about July 1st, 2023 in Jefferson County, Texas, you operated a watercraft while intoxicated. You understand what you were charged with? Yes, sir. Paragraph 2 goes on to allege that that you have 2 or more prior convictions of operating motor vehicles while intoxicated, beginning, 30 years ago. And in 94, out of County Court of Law 1, 97, County Court of Law 3, both of Jefferson County, Texas. Then 2013, here in the Criminal District Court, 2 convictions in September 2013, and then another one in 2017 out of the Criminal District Court here. So you've been a subject to 3rd-degree felony because of prior convictions of DWIs 3 convictions ago. What was your sentence in this last case in December 7, 2017? 8 years ago. The last one you got. Pull that up. It's 17-27669.
I believe it was 6 years, Judge.
Dustin's generally right. We have a problem here that needs to be addressed differently than what we've addressed before.
Here's that. Judge, this case is a little different, even though it is still an intoxicated offense. It's a voting while intoxicated. I know you have the probable cause affidavit, but it was a result of a safety check. And he was brought ashore and eventually arrested driving a jet ski.
Yeah, but it's personally for him and his own health. It was a .207. It was a true breath test. I mean, that's 2.5 times the legal limit with these prior convictions. Who've had an issue.
He has addressed this issue. The court has ordered a scram device. He's been blowing into it religiously. He's never failed that machine.
It's just been going
historically. Yes,
too long of criminality, but it can't be good for your health and also the safety of others when you're operating vehicles or watercraft, right?
Yes, sir. He's asking you, it's not good for your health.
Well, I mean, what are you doing to address your alcohol issue? What are you doing? Because I mean, you've been held accountable since 94, and you're still misusing, overusing alcohol. Right? That's what happened here.
Yes, sir.
So I'm asking, what are you doing to fix this?
Are you still drinking?
We don't want you back up.
Yeah, I'm not drinking. That's,
When did you stop?
oh, I've been stopped for a minute.
Since July of 23? This is when this happened.
Yes, sir.
So that's that's 2.5 years. Okay. We hadn't had any problems since then.
Well, I think as you mentioned the breath test point two, I think it was pretty close to that. I thought it was just a little lower, but I don't, 0.18. I split beans, but I think he wanted to make sure he didn't mishear it.
I believe the 0.2 came from their VBT.
Yeah, that's what that
PBT.
Yeah.
Right.
But the actual breath test was a 0.185.
Yeah, he quit drinking as a result of this, Judge, but he can't prove that other than when the court ordered on the scram device to monitor him, he has not failed that scram device at all.
Yeah, and then at the jail, he provided 2 breath samples of 0.185 and 0.180, but that 0.207 was still pretty close. Yeah, because it took a little while to get those subsequent samples drawn, but I mean, that's, and it's been 2.5 years, but we hadn't had any problems at all.
No.
Right? Yes, sir. Do you go to Alcoholic Anonymous or anything, any programs like that?
I was, and then I have a system. He works plant where, so I'm working out there at the PALMG site, so I'm out there.
What do you do?
I'm a foreman for him on the tank side. Got brought in right
We
there.
got responsibilities there, leadership, role modeling. They're not drinking on the job, are they? All right. What would you do about that? Hold them accountable. What would you do as a foreman? All right. So in this second paragraph, it is alleged that you have 5 prior convictions of operating motor vehicles in public places while intoxicated. Paragraphs 1 and 2 constitute a 3rd-degree felony if convicted. Do you understand what you are charged with here in this indictment? You are facing, God bless you, if convicted, a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes, I understand the question. The agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison.
Yes.
Just want that to sink. Boy, that sounds horrifying to me. That would be suspended. You would be placed on regular probation for 10 years. There would be terms and conditions of probation, which are normal and customary for this type of offense. You must also serve at least 10 days in the county jail as a condition of probation. And there will be terms and conditions of probation, which are normal and customary, which include not operating a motor vehicle without an interlock device. Do that. You always have to have that. Is there any reason why we need to order any kind of program? Judge, there'll be a DWI program that's normal and customary. Anything else we need other than that, do you think, for him?
Judge, I would just say based on his track record of
2.5 years.
So improving that he's not drinking through the device, he's probably past that point.
You want to sign the bottom of it.
Should just be able to tap out.
You just signed it off. Oh, I'm sorry, the judge. I'm asleep on the job. Just because I know how you are, Dustin. You're reluctant to put your name on anything here. He's good. All right. Do you understand here what you're charged with in this case, in these two indictments, in these two paragraphs of this indictment, sir? How do you plead to paragraph 1, charging you with operating a watercraft while intoxicated, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? And those prior convictions here, there are 5 of them from 1994 through 2017 of DWIs operating motor vehicles while intoxicated. You understand fully what this alleges, and are these allegations true and correct in paragraph 2, and are you pleading true and correct to those voluntarily?
Yes, sir.
I've shown you what's marked as State's Exhibit 1. You've read this or discussed this with your attorney. Are the provisions in paragraph 1 all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State, is all that true? You've got to, you can't take a nod. You've got to express it out loud. That it is all true.
Yes, sir.
Okay. State's Exhibit 1 is part of the record without objections. I'm going to follow this agreement. Anything else to add?
Just a judge on the 10 days, because he does work at the refinery and he's a foreman, we'd ask that the court would allow him to do that on weekends starting next weekend.
Are you're free on weekends to?
Well,
have you made arrangements to do it?
Sure.
You're going to have to report on or before 6:00 p.m. each Friday, and then they release you on or before 6:00 Sunday, and you get 2 days credit, and so it's going to be 5 successive weekends.
Yes, sir.
Right here is painful to go in, you leave, and you go, oh, I don't want to go back to there, and then you got to do that 5 times. But we're going to accommodate your request so that you can handle your job responsibilities. Most importantly, make sure you do that soberly.
Yes, sir.
Yeah, there was a sheet.
No, that's fine.
All right, I'm going to make the findings that Mr. Mixon, you are pleading guilty to paragraphs 1 and 2 and true to paragraph 2, constituting a 3rd-degree felony of boating while intoxicated with 2 or more prior DWI operating motor vehicle in public places while intoxicated convictions. This is a 3rd-degree felony. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now so find you guilty beyond a reasonable doubt of this 3rd-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice prison for 10 years. But I'm going to suspend that confinement, place you on regular probation for 10 years. There will be terms and conditions of probation that the probation office is going to go over with you that I have signed. Make sure you understand them fully. You will be held accountable for those. If you fail to follow those, your probation can be revoked and you can be sentenced up to 10 years in prison, which you don't want. There, among other terms and conditions of probation, you must serve 10 days confinement in jail. We will do that, order that to be done on 5 successive weekends. You must report on and before 6:00 p.m. each Friday for 5 successive weekends. When can you begin that?
On the 16th, which would be 1 week from today.
1 week from today, January 16th of this 2026. You understand what has happened today, sir? So, okay, please see the probation officer. Good luck.